Good day! In this video, we will be discussing the similarities and differences of special laws. These special laws deals with child trafficking, child pornography, child abuse, exploitation of persons, publication and distribution of pornographic materials, and sexual harassment.
Child trafficking under 7610 and RA 9208. In 7610, child trafficking is done with coercion and influence, and the children is subject to exploitation and prostitution. And in this special law, attempted child trafficking is punished. While in 9208, the means of commission of a child trafficking by merely transporting, harboring, or receiving, and it also gives emphasis to the adoption process as one of the means of its commission. And trafficking of person to a child is punished by qualified anti-trafficking of person in this special law.
Now let's go to child pornography. Child pornography refers to any visual, written material, or audio presentation, whether or not it is made by electronic or mechanical means, or an actual presentation of a child engaged in a real or simulated explicit sexual activity, or showing his or her sexual parts or anal region, the dominant characteristic of which depicts a sexual purpose. It was passed into law because RA 7610 and RA 9208 failed to address the following: the appalling activities of pedophiles, the prosecution of persons possessing child pornographic materials, the importation and exportation of pornographic paraphernalia. Compared to RA 7610, RA 9208, under RA 9775, a child is defined not only as someone who is under 18 years of age. Here, the child may not be a real child. A cartoon character depicted as a child can be considered as a child. When child pornography is committed through a computer system, the offender can be prosecuted under RA 10175, which is also known as Cybercrime Prevention Act, and the penalty to be imposed shall be 1 degree higher than that provided for in Republic Act 9775.
Child Abuse in Republic Act 7610. It is for the special protection for children under 18 or those over but are unable to fully take care and protect themselves from any acts or series of acts committed by the parent, guardian, teacher, or person having care and custody of the same from all forms of abuse, neglect, cruelty, and exploitation and discrimination and other conditions prejudicial to their development. However, the said Abuse in Republic Act 9262 is an act that values the dignity of women and children and guarantees full respect for human rights and recognizes the need to protect the family and its members, particularly women and children, from any person who commits the act from violence and threats for their personal safety and security.
Take note that injury committed against a minor is not automatically child abuse under Article 7610, unless it caused some degree of psychological effect on the minor or is cruel. Also, it is important to take note that it is required under VAUSI law that the offender has or had a sexual or dating relationship with the offended party. For RA 9262 to be applicable, it is not indispensable that the act of violence is a consequence of such relationship.
In the anti-VAUSI law, the victim is specific. It should be women and their children. But in Anti-Trafficking in Persons Act and in Anti-Photo and Video Voyeurism Act, it does not distinguish. The victim could be a man. However, in the Anti-Trafficking in Persons Act, the offense is qualified if the victim is a child. In the Anti-Trafficking in Persons Act and Anti-VAUSI law, the consummation and the mere attempt of engaging in the victim in pornographic or sexual exploitation is already a violation of these said laws. In the Anti-Trafficking in Persons Act and in the Anti-Vowsy Law, the victim is subjected to force, threat, coercion, and other physical harm. In Photo and Video Voyeurism Act, taking of a photo or video of a person or a group of persons performing sexual act and distributing or selling these photos or videos without the consent of the people involved.
Now we will relate the publication and distribution of pornographic materials to four special laws. In RA 9262, Anti-Violence Against Women and Their Children Act of 2004, in Section 3, one of the punishable acts under this law is the psychological violence of causing or allowing a woman or child to watch porn where mental and emotional suffering are inflicted on them. Publishing porn is not included here, but distributing for the purpose of showing it is limited to a woman or child victim. In RA 9208, Anti-Trafficking in Persons Act of 2003, the main crime of recruiting, providing, or receiving a person either in the guise of employment, marriage, travel tourist, adoption, for the purpose of making money out of prostitution or pornography are few of the many prohibited acts in this law. The victim can be of any gender, and the publication and distribution of pornographic materials here is secondary to the crime of human trafficking. In RA 10175, Cybercrime Prevention Act of 2012, one of the many forms of cybercrime refers to content-related offenses such as cybersex and child pornography. Here, the cybercriminal uses a computer, a program, or the internet to publish and distribute pornographic materials he acquired through cybersex and child pornography. And if the child pornography was done using a computer system, due to its perversity, the penalty will be higher than that imposed in anti-child pornography law. As for RA 9995, Anti-Photo and Video Voyeurism Act of 2009, the punishable acts include the very act of taking a photo or video of a person or a group to capture their naked or undergarment-clad genitals, pubic area, buttocks, or female breasts without the consent of the persons involved. Important to note here that the victim of any gender was peeped upon under circumstances which she or he has a reasonable expectation of privacy. Second prohibited act is copying or reproducing the sexual material with or without consideration to sell or distribute either the original copy or a reproduction of it. Fourth is to publish or broadcast, show or exhibit the sexual photo or video recording taken without consent. Under this law, it only becomes a crime when this was done without written consent or against the will of the victim, even if the victim agreed to be recorded but did not consent to it being distributed.
Vowsy defines violence against women and their children as a public crime. It is the umbrella that guarantees the fundamental rights of women and children as inscribed in the Constitution. The Anti-Sexual Harassment Act recognizes that sexual harassment occurs in work, education, and training environments. It penalizes persons who have authority, influence, and moral ascendancy in such institutions. However, it does not cover other incidents of sexual harassment, such as those in the streets, public, and online spaces. That is why the Safe Spaces Act was signed into law to expand the definition of sexual harassment in the workplace and education or training environments. The main difference between the sexual harassment under RA 7877 and RA 11313 is that, under the former law, consent by the victim is immaterial. The rationale of the law is there is an imbalance of power between the aggressor and victim because of the former's position or designation.